And I just want to kind of summarize 2 points to make about this, which is a point that I found that a lot of people were concerned about at the COP in Egypt, and I would say there is. We were talking earlier in the day about some of the religious kind of tendencies, that some of the religious tone and persecution of heretics and stuff like that we see certainly represented at the COP in Egypt. But at the United Nations COP, there's a lot of people that are focused on practical problems and that are willing to spend time thinking about this. And I was able to spend a lot of time in Egypt at the COP talking about this issue, and it's an issue that a lot of the scientific community is not aware of, because it is such a legal set of problems. And even when I graduated from law school, I don't think I knew what the National Environmental Policy Act even was. So you could actually graduate from law school and not even know anything about the law that results in these enormous problems that we're going to be talking about today, except to say that and Karen has seen this for even longer than me and has seen it up close, actually Michael Buschbacher as well from inside the government. We have the system for federal permits and environmental reviews is an enormous, maybe the single biggest obstacle to achieving net zero that we face, and it's not even a footnote in the World Economic Outlook of the International Energy Agency or any of the studies that we've seen. I saw a study. Some California Electrical Modernization Foundation that said, in order to achieve net zero, we just need to triple the pace of permitting, right? And if they knew what huge obstacles there are to even increasing the pace of permitting by 5%, they would realize that under current law, it's impossible. I mean, the current law would have to change in order to make these things possible. And the obstacles operate at 2 levels: a micro level and a macro level. And I'll just say a couple words about the micro level, which is that for any solar project out west where the sun shines 365 days a year, which it does not do in the Sunshine State, by the way, you're going to be on BLM land and not private land. And if you're on BLM land, you need a specific permit with a site-specific environmental impact statement to get your BLM permit. And that is a $25 million odyssey for the project. There are people who are in the business of just developing the permit application, and then when I get the permit, I sell it to you for $25 million. And all I did was a permit application. And it took 3 years, and it involved millions and millions of dollars of reports on the turtle and the historic preservation site and the other thing, all the resource reports that the agencies are going to ask for. And the reason why the agencies ask for all this stuff is that you could get 999 pages of your 1,000-page environmental impact statement totally correct. And if you're missing one thing, a court's going to say that you didn't take a hard look and will vacate your permit. So you've got agencies that are driven by unavoidable litigation risk, and it's not true that they're not exaggerating it. They've got it quite right. That they're driven by litigation risk to bulletproof these environmental impact statements, and they've got all of the engineers and all of the scientists that are working in the BLM regional offices are on the same program. They have to do it right, or they're not doing their job. And as a result, the permit application takes 3 years. And when they get to it at all, because the whole system is built to elevate NIMBYism above things that are in the national interest. In Australia, you have these things called nationally important projects that you get designated as a nationally important project. It preempts, it creates a streamlined system and preempts local obstacles. In Europe, the European Union just passed a directive that would require nations to permit solar and wind projects in 3 months, preempt all local opposition. That's impossible. I can't even imagine what that would look like in the United States. This system has been developed by the environmental and progressive wings into a system that systematically and you could could say, describe it positively. It gives voice to local opposition and local concern to the point where it elevates them above national policy priorities and makes it very easy to block any particular project. And I could just run through a list for you of projects that you think to yourself, if this project is going to fail because of the opposition of that group, the Biden administration is not going to come within 5% of its net zero target, right? And so that's the first level that it operates at, is the micro level, which is how easy it is to block a particular project. There's an even more important constraint that operates at the macro level, which is that the process of producing a permit and conducting an environmental review under the National Environmental Policy Act is so resource intensive in terms of agency resources, full-time equivalent hours that the agencies have to spend processing these things, that the entire federal government can produces at most 75 environmental impact statements a year, or 80 environmental impact statements a year, of which like maybe 2 or 3 are solar project permits. And if we need 500 gigawatts of solar to get to net zero by 2035, that's like 1,000 utility scale solar projects that need to be permitted and built. And we'll just, math is not my greatest strength, but at a rate of 2 or 3 permits a year, we're not going to get to 1,000 permits in time to build 1,000 plants by 2035. So that's I think it's very important to stress this because, Senator Sheldon Whitehouse would love to persecute the climate heretics, and he thinks that it's oil companies that are the obstacle to this. It's not. The obstacle to the deployment of renewable energy on the scale that would be required to achieve net zero by 2035 or even 2050 is very simply the National Environmental Policy Act. And so, with that, that's my little diatribe that I wanted to go into, and I'll try to be quiet as much as possible. We're joined on a panel by people who are steeped in all of some of the nation's greatest experts in the very issues that I've been talking about. First up, we're going to hear from James Coleman, who's a professor at, let me get your bio straight. James Coleman is a professor at Southern Methodist University's Adelman School of Law and a fellow of the American Enterprise Institute. He received his undergraduate degree in biology and his law degree from Harvard University. After law school, he practiced energy and appellate law at Sidley Austin in Washington, D.C. Before SMU, he taught at the University of Calgary's Law School and Business School. He also served the provincial government as part of the Alberta Royalty Review Expert Panel, which modernized management of Alberta's oil and gas resources. Before Calgary, he served on the faculty of Harvard Law School as a lecturer. Then James will be followed by David Adelman from the University of Texas School of Law, and by the way, that follows a conversation that I believe you've been on at least one panel together. We've
had 2, and just sort of dialogues on permitting. One's back when you were at CE2, I think, and then the other one on the sort of on the mansion bill. Right.
Great. And the reason why I wanted to and the reason why I wanted to bring both of you back onto this with Michael and Karen is precisely to continue that conversation, which I think is a very valuable conversation, and a very valuable contribution to the debate. So David Adelman teaches and writes in the area of environmental law, intellectual property, and climate change policy. Professor Adelman's, as I said, University of Texas Austin School of Law. Professor Adelman's research focuses on the main interfaces between law and science, which is what this conference, of course, is hoping to do. His articles have addressed such topics as the implications of emerging genomic technologies for toxics regulations, the tensions between legal and scientific evidentiary standards in regulatory decision-making, and development of effective policies for promoting innovation relevant to addressing climate change. He clerked for the Honorable Samuel Kahn of the United States District Court for the Northern District of California, And before entering academia, he was an associate at the law firm Covington & Burling in Washington, D.C. And then we have Michael Buschbacher, who is a partner at Boyden Gray Associates in Washington, D.C. Mr. Buschbacher represents public and private companies, trade associations, nonprofits, and individuals in high-stakes litigation and administrative proceedings with a particular focus on environmental and energy matters. If you all don't recognize the name, Boyden was White House counsel under President Bush, George Bush 41. Michael is a frequent commentator on legal and policy issues and has been published in the Wall Street Journal, Newsweek, The American Conservative. Before joining the firm, Mr. Buschbacher served at the U.S. Department of Justice as counsel to the Assistant Attorney General for the Environment and Natural Resources Division, where he was looking up close at the hundreds and hundreds of NEPA cases that the ENRD division is prosecuting at any given time. Because, I forgot that I think in EIS, isn't it true that an EIS has a litigation risk of 100%? Every single one of them gets sued. So half the cases at ENRD are NEPA cases, which is an incredible fact. That's 1/4 of the Justice Department. I mean, that's half of 1/4 of the Justice Department in Washington D.C. is taken up by cases defending the government from essentially either industry or environmental advocacy groups seeking to block one or another permit for one of these things. Karen Hanley joined us just on time. Who's been in? She moved to South Florida just a year ago. We're already getting Cuban time. It's getting insane. Karen joined the Permitting Institute, which was launched by Alex Hergot, another colleague of ours from the administration after he left the White House. Karen joined the Permitting Institute in September 2021 from the Federal Permitting Improvement Steering Council, what we call FIPSI, which is a council set up under the FAST Act to process major permit applications for covered projects, and love to hear your experience from the effectiveness of FIPSI, because I think it is definitely a model that can be built on. She served as the country's top interagency permitting expert, helping agencies and project developers alike navigate and align permitting processes and requirements to save time, eliminate risk, increase transparency, and preserve natural resources. She is known as the go-to expert on adjudicating issues among multi-jurisdictional authorizations. Karen's extensive experience also includes civilian services to the U.S. Coast Guard when she worked on the environmental analysis for national and international maritime rules, and she's coming back home. I think you went to school here. So thank you very much. James, thank you very much.
All right, I might stand up if that's all right.
Sure.
So, well, thank you so much. It's so wonderful to be here. I've really enjoyed getting to talk to some of you beforehand. I apologize in advance that I'm going to have to miss the rest of the conference, which looks amazing, and we'll be running out either immediately after this ends or possibly a minute early. So, just so you know, you can get in touch with me. I'd love to hear any of your thoughts on these very important issues, and well framed in terms of the centrality of this permitting question. Because one thing we've heard throughout today is, well, the U.S. now has a climate and energy policy. It's the Inflation Reduction Act. It's almost $400 billion of spending. I always think when you have numbers that high, it's important to divide by the relative population to get a sense of that. So it's about $3,000 per American household. So what are we getting for our money that we're spending on this? And I think one of the overall goal is really twofold. It's to move some of the crucial parts of our civilization, like heating and transport, to dependence on electricity rather than on fuels. So think about like electric vehicles or electric heat pumps. But then at the same time, to clean up the electricity system as well. And so make it more dependent on zero emission sources like solar and wind, rather than sources that result in more carbon emissions. And so that's really the twofold goal. But one of the big challenges that I'm going to dive into a little bit more today is that both the electricity system can be cleaner than fuels in terms of their air emissions, but is in some ways a more fragile system, and that is going to require a lot of investment to fix. And I'll talk about that. And the second really central irony is that if you take the energy system, the different sources that we could use, and you kind of put it on a spectrum from dirty coal, a little bit cleaner oil, much cleaner natural gas, electricity with zero emissions. Unfortunately, that's also a spectrum that shows you how easy is this thing to transport, like coal and oil that you can ship by many multiple methods, versus electricity and natural gas. And that turns out to be a really crucial issue for the reliability of the energy system and for human well-being. Because if there's a shortage of oil anywhere in the United States, it's very easy for any place that has enough oil to ship more. They can send it by water, by tanker, by barge, by vessel, by rail, by truck. There are lots of ways to send it. But if there's a shortage of electricity, then you're gonna have to try and shift supplies from somewhere new. It's gonna take years, possibly more than a decade, and billions of dollars to build a power line to bring a source of power to that market. And so that creates a central challenge, which is that if we want to make this new system more dependent on electricity, we are going to need to build a lot of new infrastructure to make that system as reliable as the energy system we've come to depend on. So today I'll first kind of describe a little bit more about that challenge of building a cleaner energy system based on electricity backed by basically renewables plus natural gas to make up the difference when renewables aren't available. See some of the challenges with ensuring that provides a reliable system of energy. And then second, I'll talk about some of the growing challenges to building that infrastructure. And certainly the National Environmental Policy Act, this our environmental review statute here in the United States, is one of those central challenges. I'll talk about some of the reform proposals that are out there. So first, this big question: can we have an energy system that instead of using fuels is really dependent on electricity and on pretty much natural gas and renewables for electricity? And I think it's important to first understand, when we're talking about moving sectors of the economy, like heating, like transport, those non-negotiable parts of our civilization, to electricity, where is that electricity coming from? Well, basically you divide US electricity production into fifths. And 2/5 comes from our biggest source, which is natural gas. Then we get another fifth from renewables, that includes both solar, wind, and hydro, right? We get another fifth from coal and another fifth from nuclear. But you can also see from this chart that two sources are really on the rise: natural gas and renewables. Increasingly, that is, if you were to project that forward, what's expected is that in the future we will be more and more dependent on natural gas and renewables. And we will see that in certain ways, those two sources work very well together, but they also create some serious challenges for the reliability of our energy system. So first, I think one central fact about the energy system that is too little appreciated is that the grid managers have to balance every second how much power is being demanded by millions of consumers every time they plug in their television, plug in their Tesla, have the heat kick up, versus the amount of power that's being provided by hundreds of power sources. And so we can see how the grid managers manage this feat by just looking at a normal day. This is the California grid, March 26th, 2017, nothing went wrong on this day. But what you can see from the overall level of the chart is how much power is demanded from midnight to midnight. And maybe as you expect, after midnight, people go to sleep, it goes down a little bit. As people wake up, you see it gets higher during the middle of the day. And then the peak of demand is in those early evening hours. Now I want you to look at the different colors on the chart. And those are telling you what sources of power are providing power to the grid. And what you can see here in yellow and green, that's solar. And you can see it provides a ton of power during the middle of the day. Now that's great because it allows us to ramp down our natural gas, which reduces our emissions, reduces our expenditures on natural gas. And you can see that, unfortunately, there's no solar available when we most need power in those early evening hours. And that's fairly typical around the country, that that's when we have the most power demand. And so you see that natural gas and other sources have to ramp up to meet the full demand with no assistance from renewables during that time period. Okay. I think maybe what's slightly less appreciated is that in addition to solar not being available during those early evening hours when power demand peaks, often wind isn't available either. So I think everybody might imagine, if you look at this top GIF on the right, you're seeing solar power, a wave of solar power going across the United States at solar noon. On the bottom right, you're seeing wind power over the course of the day. And what you can see, if you look carefully, is there's a peak in wind power as well, which is in the early morning hours, when unfortunately power is least needed in most of the country, and there's a minimum in the early evening hours when we most need power. So balancing the power grid using the solar and wind is a big challenge every day. Basically, natural gas has to be there to fill the full gap. Now, it can be an even bigger problem seasonally. And so what I'm showing you here is the sources of power that are bringing power to the Texas power grid over the first 2 weeks in February 2021, leading up to those Texas blackouts. Now, in the first half of this chart, what you're seeing is in red, you're seeing that often the biggest source of power on the Texas grid is wind power. Nowadays, it provides about 25%, about a quarter of our power. You see, it's often the biggest source. Then in orange, you're seeing natural gas, which ramps up when the wind power isn't available to fill that gap. You'll notice something changes in the second week. Well, what changes? Well, it got very cold. And so when that happens, and this unfortunately is often the case, wind power went down to a minimum. That's not because of wind turbines freezing necessarily. That's just because it's often the case when it's very cold that there's not much wind power available. And so you see that in orange, natural gas had to ramp up to meet that full demand when wind power wasn't available. It actually ramped up to unprecedented levels. The final thing that you'll see is that in the early hours of February 15th, the night of Valentine's Day, something went terribly wrong and all the power sources drop off. Now, so what happened there? Well, actually a dozen things happened there. We could talk about all of them. But one of the key things that really led to that sharp fall off in power is, remember when I said that the power grid has to always exactly balance how much power is being demanded with how much power is being provided to the grid? Well, what happened is those things fell out of balance for a few minutes in the middle of the night on February 15th. And the consequences were catastrophic, because what happens when they fall out of balance is the frequency of the grid changes. The grid normally oscillates at 60 hertz, right? 60 times a second. And if there is less power being put on the grid than pulled off of it, what happens is the frequency changes, it drops. It dropped down as low as 59.3. You can see this is actually a picture of just 30 minutes in the middle of the night on February 15th. And when the frequency of the grid drops, everything, all the power plants that are connected to the grid start to break. And they start to trip off of the grid to protect themselves from breaking, which in fact increases that imbalance, leads to a chain reaction. That chain reaction took down the grid. It really started in just a couple of minutes in the middle of the night, took down the grid for about 4 days, over about 250 Texans died. And so you can see that the power grid based on solar and wind, although much cleaner, has this fragility that makes it incredibly important that we build enough capacity to ensure that we can always provide sufficient supplies, that we never have these kinds of imbalances. Okay. That is particularly a challenge because as over time we have seen growing challenges to building that new infrastructure. One way that you can think about that is those Inflation Reduction Act subsidies. We're each spending $3,000, all of us are spending $3,000 on those subsidies. How much benefit are they going to make in terms of providing solar and wind to clean up our system? Well, based on the same studies that were used to justify this spending, what they've suggested is that basically we would only get about 1/5 of the benefit that we were promised if there is not a substantial acceleration in our construction of power lines. And so basically this will have almost no impact, all the money that we're spending, unless we substantially accelerate that. And that's because if you look at where those sources are available of renewable energy, they tend to be available, this is showing in the middle of the country where transmission is least available to get them to market. And so that's why one of the big holdups for them is those interstate power lines, being able to build those. Now, what are some of the challenges that are occurring? Well, one is we have an unstable regime for how those are permitted. Historically, you would have said that interstate power lines just had to have approval from every state that they've crossed. But one thing that we have found over time is that the federal government has asserted increased authority to also impose another level of regulation on top of that, which is that, and you're seeing that it's actually initially developed a lot through pipeline proposals, but they have a similar system in that the hook for the federal government is federal waters. And then you have these NEPA reviews, which over time have been growing more lengthy. So the second thing to say is that even if you federalize the process, and that's one of the reform proposals that we have, the one challenge is that the states have found ways that if they don't like a project, they are able to veto it. And it kind of goes back to that vetocracy that we talked earlier, Fukuyama's idea, that ability to stop a project that they don't like. And so we're seeing increasingly the ability for either federal or state policymakers to stop any project going forward. Now, in terms of the environmental reviews, and I'll end with this plus the reform proposals. One is that we have seen those environmental reviews lengthen over time. This has been recognized by a problem by succeeding presidents, by President Bush, by President Obama, by President Trump, and now by President Biden. But if you look at it, even as they've tried to take efforts to speed up these reviews, they have taken more and more time over time. So at the end of the Bush administration, they took 3.5 years. At the end of the Obama administration, they took over 5 years. President Obama's regulatory czar compared the permitting system to the blob, and it's been completely unstoppable in terms of stopping any new infrastructure. Now, that's led to all these kinds of headlines that you see, not just the permitting system stopping oil pipelines, but also a number of important renewable projects. Now, the proposals that are out there for reform, I mean, Senator Manchin has said, one, he wants to have more federal permitting so that individual states can't hold things up. For me, the challenge with that is individual states are already holding up federally approved projects like natural gas pipelines. So it's not clear to me that that is a potential benefit. He wants to impose time guidelines on environmental reviews. Now, unfortunately, the problem with that is that's not on the courts, that's on the federal government. And generally, telling the federal government it has to do something within a period of time, it has no need to listen to you really, and of course included exceptions. One thing it would have gotten billed is it granted permits to the Mountain Valley Pipeline and exempted them from judicial review, so the Mountain Valley Pipeline really would have been built. I mean, as for me, sort of as an academic, it's kind of like, okay, I get it, you can get one project built. It's not really a procedural reform. In terms of other proposals that are out there, a couple things that I propose. One is that there be some time limit on the ability of courts to stop the project so that they could continue to order the agency to go back and do more environmental review if necessary, but not be able to stop the project from going forward after some period of time. And the second is that states are using Clean Water Act Section 401 reviews to veto federally approved projects. And one thing I would suggest is that FERC should have a chance to review those decisions before they're appealed to the federal court so that FERC can say, you know what, I get it, you don't like this power line, but we don't really think your concern here is about water quality. You don't want this project, it's nationally important, we have to let it go through this court. The states would still have their day in court with the federal courts, but we would have a FERC record to potentially for the courts to defer to. So with that, there's a version of these slides up there. I'd be happy to talk with any of you if you all want to email me, and I very much look forward to the other presentations and to your questions.
On track here.
We've got 10 people.
Okay, then I don't have to worry about it. I'll try and keep my eye on it. So I'm going to tell quite a different story about permitting and federal infrastructure. I'm going to focus mostly on wind and solar, say a couple of things about transmission. And basically the idea for the project was really simple. It was, we're worried about litigation, we're worried about permitting of these major projects. how often do projects actually have to get key federal permits, given the number of projects that are getting constructed on an annual basis. And so basically, when you look at the major environmental statutes that are at play, as we've heard, there's the National Environmental Policy Act, the Clean Water Act, Section 404 permits, which are wetland permits, and the Endangered Species Act, which is, from my perspective, probably the most important one, probably not NEPA. There's also the Legal Protection Act, the GEPA, and the Migratory Bird Act. And I'm not going to talk about those, and I don't currently have data on those. And so what I'm going to do is give you the punchline, then talk a little bit about litigation, and then sort of depending on how we're doing on time, go through a little bit more of the data in a little bit more detail. So what I'm doing is I'm looking at all permitting and litigation between 2010 and 2021. Over that time period, approximately almost 800 wind projects were constructed around the country, and a little over 1,100 solar projects were constructed around the country. And solar projects, this is an LBNL study. They define them as 5 megawatts or higher. So not huge, but there's not the really small solar projects. So what I'm capturing here is solar projects that are at least, 25 to 50 acres in size. And so you'd expect that it could raise, some issues, particularly under the Endangered Species Act, even at that relatively small scale. So when we look at the data, we have to look at it, and we look at the number of EISs required for wind projects, required for solar projects, over 10 years. So this is the aggregate number of EISs required for wind projects. Remember, there were almost 800 constructed over this period of time. There were 26. So that's roughly 2 to 3 per year, 29 for solar projects, and then 2 to 3 per year. And so just in just percentage terms, that's about 2.5 to 3% of the projects requiring an EIS. So it's a little, when you start looking at the actual numbers, what you're seeing, and this is very much consistent, I talked to lots of developers in Texas, and just as folks are talking about, they want to avoid the Endangered Species Act, they want to avoid Section 404 permits, they want to avoid having a federal nexus and having to do an EIS, and it turns out they do that very well. They've got sophisticated attorneys that are working with them, they do enter into significant negotiations, particularly with officials from the Fish and Wildlife Service. And so, for the most part, 98, 97% of the projects, they don't have to go through an environmental impact statement. That doesn't mean there isn't some level of environmental review. Unfortunately, we don't have any federal data on categorical exclusions, which are relatively simple to get through, and we don't have any data on environmental assessments. But those typically can be completed in 8 months to a year. Projects, even in a place where they're developed really quickly, like Texas, would be 3 to 5 years. That's really not going to hold up a project. And again, totally anecdotally, talking to attorneys and project developers, they're, at least to me, they're not saying that the environmental statutes are getting in the way. They complain sorely about NEPA and the ESA, but when you really push them, there are other issues that they say are the most important ones, particularly grid interconnection issues are the ones that at least most people seem to be talking to me about. Same sort of data with regard to Section 404, 18 permits. Again, this is over a 12-year period. It's over all wind projects, about 2.5% of the projects. Solar projects, 23 permits, about 2% of the projects. And for HCPs, for wind, 33 HCPs nationally, about 3 per year, and solar projects, HCPs, about 1 per year. And so what that suggests is the project developers, at least so far, have been able to navigate around these statutes. And that doesn't mean that that's costless. There's a complex and sometimes really difficult and costly It can actually impact the way the site or the way the project is constructed, and even maybe how it operates, and therefore the economics of the project. So I don't want to suggest at all that there are no costs associated with developing a project in the shadow of these environmental statutes, but there are important streamlining functions or mechanisms under the Endangered Species Act, mostly just negotiating around having to get an HCP or creating a trigger that forces you to go through Section 7 consultations. Under the Clean Water Act, there are what are referred to as nationwide permits, and so those are, in essence, permits by rule. You can get them very quickly. They don't trigger NEPA in most cases, and they typically, although not necessarily, don't trigger Section 7 consultation. It just depends on the nature of the specific project. So the system, at least as I see it from these statistics, has flexibility built into it. And we see sophisticated developers navigating reasonably effectively so far around the major federal environmental permits that these types of projects could be subject to. With regard to litigation, so that I was just talking about permitting. This is looking at litigation involving wind and solar projects doing a broad search of the existing federal databases for all the potential, at least what I thought of, all the potential environmental statutes that could be the basis for a claim or a challenge to a wind or solar project. And so you see, as you might expect, NEPA is the statute that these projects are most commonly litigated under. So for wind, it was 21 projects had NEPA claims, 14 solar projects had NEPA claims, 14 transmission projects, and then ESA, and then Section 404. The total numbers, again, are kind of strikingly low. For wind projects, 29, for solar projects, 15, for transmission, which is totally shocking to me. And these are, I want to emphasize, these are all very provisional numbers here. I want to like double and triple check them. 15 cases. They're not distributed uniformly. Wind a little bit more, but a lot of the litigation has been concentrated in California and the Northeast, particularly around the offshore wind development. The solar projects, those are basically all concentrated in California, and really all in the sort of sensitive kind of southeastern desert areas in California. Some of these are the big thermal solar projects. They're not photovoltaic projects. A number of them impacted tribal land, so there was tribal opposition to these big projects. And these are kind of unique, they're unique desert ecosystems. And so that seems to be part of the theme here. So we're seeing, you know, if you think about Cape Wind, probably not the best idea to build the first utility scale offshore wind project, even though it was tens of miles off the shore of Cape Cod, where you have the wealthiest, most politically connected people in the country, sort of hyper NIMBYism there. And then I think the sort of the southeastern desert areas of California is just a little bit more complicated. It's sort of an area of unique ecological significance, particularly to both tribes and a variety of environmental groups too. So overall, the numbers are relatively small, and if you even 10x them, just to give you sort of a sense of things, the number of EISs, go to this, has been declining over about the last decade. It's dropped in half. It was typically in the range of like 200 to maybe 250 per year, and that's across the entire federal government, all programs. And you think about the number of potential decisions or actions at the federal level that could conceivably be subject to NEPA, it's most certainly in the thousands. The best data we have are less than 1% of projects that have a federal nexus are subject to an EIS. And what these data show is that number's been going down monotonically across multiple administrations over time, which also means, presumably, that the remaining projects that are subject to an EIS are essentially creating a higher threshold and probably more complex. And that may be one of the reasons why it's so damn hard to get the time for preparing an EIS down. And it's also really important to keep in mind that an EIS, the time it takes, isn't just driven by the EIS process. EISs operate as an umbrella to very complex processes, especially for big projects over time. And it may not be the EIS process that is the rate-limiting step. In fact, a lot of people think it's not. Yeah.
Just a quick clarifying question. Is this every review or reviews that are related to infrastructure?
This is everything. This is the
So it could
aggregate
be
data.
cutting trees or
On the bottom, blue is the draft EISs, the red is final EISs, and the top two are some.
any kind of region.
Yeah, but this is the total number. So, as a total number per year is, well, the last couple of years have been relatively low. It's only about, it's less than 100 in 2021, 2022 for the entire project. I think I'm down to how much time? 30 seconds. I just want to say, like, if you look through, if you break down, this is looking at EISs, the other, you sort of see kind of clear patterns based on the lead agency. And so it's almost, for solar projects, it's almost always on federal land. Oftentimes we see either it's on federal land or there's a direct federal actor. It's only about a third of the cases in the case of wind projects where it's basically a federal permit that is the federal nexus for requiring an EIS. And so we sort of see EISs occurring more when we're dealing with federal land, but again, the numbers are relatively low. And then I'll just want to emphasize, this is the aggregate number of HCPs per year. It may be a little bit hard for you to see. It's broken down by region, which is just a geographic breakdown of HCPs. So HCPs are the plan that is prepared when you get an incidental take permit. So this is the permit that you get under the Endangered Species Act. And it's only about 20 to 30 per year. And so talking to people within the Fish and Wildlife Service, there's actually an aversion within the agency to preparing these HCPs, and these data very much bear that out. It's sort of extraordinary to me, given the number of projects that you might conceive of being subject to requiring an incidental take permit. This is national numbers across the board. We'll only seeing 20 to 30 per year. And then if we look at HCPs, it's really sort of unique resources like Hawaii. So Hawaii's it's not some wind development, but small compared to the big states in like Texas or the central part of the country. Or it seems to be for wind, the Midwestern states like Indiana, Illinois, Ohio there, and that's really driven by bats. And bats, I would say, are a big issue for wind, and probably going to be an increasingly challenging one. For solar, it's all in California and Nevada, and it's the desert. The endangered desert species. And so we've got sort of these hot spots, but the hot spots really are not representative of what we're seeing over the country as a whole. There are lots of parts of the country where project developers are able to move forward without any federal permits. Okay, that was it.
Thank you. That's my co-panelists as well. It's a real honor to be here. Unlike, I think, everybody else on the roster, I'm the only normal practicing attorney. Well, I'm not that old, but I'm the only practicing attorney. So I like my clients. I agree with them about a lot of things, but I'm not here on behalf of any of them. So I just want to make that clear. These are my own views. Topic of the panel was originally getting to net zero, and then we had the Coleman obstacles and opportunities. Now it's sustainable energy. I think the change is probably mostly stylistic, but it struck me as kind of having a meaningful spin on things, because I think that the framing of net zero, especially if we're talking about obstacles, it is, I think, quite hard to even overstate. Those obstacles are very daunting. And I also suspect that Professor Nordhaus and others are right that Paris's goals are not the ideal solution from a cost-benefit perspective. So many places that is heresy. Mario tells me I'm in a safe space. And such safe spaces are relatively rare, I think, on this stuff. And I think that the narrowing of the Overton window on climate policy has created a lot of strange situations where the insistence on purity has itself created self-defeating mechanisms within a lot of climate activist goals. I'd like to go through 3 of those and then give some opportunities that I think we should pursue instead. So the first one, which James covered better than I'll be able to, is about the grid and grid reliability. The increasing use of wind and solar, driven largely by state and federal subsidies, has gotten to the point where it's hard to increase it further without further jeopardizing the grid reliability that we need. For a number of reasons. One is, the same things that lead to demand spikes, extreme cold, extreme heat, storms tend to be the kind of things that disable wind and solar when you need them most. Meredith England has called the resulting situation a fatal trifecta. She says that, I think correctly, that there are 3 ingredients, right? Over-reliance on weather-dependent solar and wind, just-in-time natural gas backstops that are not super reliable. That's a big part of what went wrong in Texas. And over-reliance on imports of electricity from neighboring states. And I think it's going to become an even more serious issue as we go forward. Hundreds died in Texas. The cost was, I think, around $300 billion. If we have a similar crisis in the Northeast, which every winter it seems like it's a pretty substantial likelihood that's going to happen, thousands of people could die. The NERC estimate, North American Electric Reliability Corporation estimate of grid reliability says that about 2/3 of the United States faces a heightened risk of power outages. So with reserve margins dropping in a lot of places, and with a lot of the transmission that needs to be built to make the transition towards more renewables possible, with a lot of stuff stuck in regulatory purgatory, I think things are likely to get worse for 2 reasons. One, I mentioned the heavy subsidies for renewables, and the second is the way that these subsidies interact with the market for wholesale electricity. So historically, we relied on vertically integrated utilities that had direct regulatory, that were subject to direct regulatory intervention from state and federal regulators that delivered most of the electricity that we used. More recently, over the last 20 years or so, there's been an enormous proliferation of regional transmission organizations, RTOs, and independent system operators, ISOs, which coordinate transmission primarily through holding auctions to determine what power plant can most cheaply meet demand at any given time. These aren't really markets in any meaningful sense. They use a market-based mechanism within this sort of quasi-governmental, quasi-regulatory, quasi-nonprofit thing. And for a number of reasons, I wish I could get into them, but they're quite complex. But the system as it exists now does not have the tools to adequately discipline those who fail to deliver. Some, like the recently departed, from his job at least, FERC Chairman Richard Glick, have just blamed climate change and said that that's the main threat to grid reliability, and that the solution is to further decarbonize it. That's just not a serious proposal. It's hot in Dubai, that doesn't mean they don't have a reliable grid. We're certainly not as hot as they are yet. The 2 more serious solutions that we see are this enormous and very costly build out of transmission infrastructure. And so if there's a lull in one place, you can move electricity from another place to that place that has a need. And the other that's often tossed around is expanded use of battery banks. I think both solutions, at least in the current form, are flawed. Building transmission out, if it's done at the right scale, could work, but it's very expensive, and permitting barriers, as I think we've discussed already, make a lot of this infeasible. If you look in the Midwest, there are all kinds of projects that are just not connected to the grid. So you've got some things moving forward, but other things are not, and that creates a problem. To give a concrete example of the magnitude of these changes, ISO New England has estimated that its system's reserve capacity would need to increase from its current level of 15% to 300% by 2040 as more solar and wind are added. So we're proceeding along this path, and the more that we increase reliance on solar and wind without building the transmission we need behind it, we're going to increase the risk of pretty serious reliability issues, and people will not tolerate being left to freeze to death. And so I think it's going to be counterproductive because, as you've seen in Germany, for instance, when things stop working, people get the coal plants back online. And that is the worst category if you're trying to reduce carbon emissions. A better approach, I think we should just get rid of RTOs and ISOs. I think they're a failed experiment. That's a heresy for a conservative like me to say in other contexts maybe, because it's a market-based system, but I think we should go back to vertically integrated utilities, which on average do as well or better than RTOs and ISOs, are more accountable, and don't do worse on emissions generally, and often are much cheaper. We could also go back, and this is another kind of heresy, we could do something like having Tennessee Valley Authority model expanded in other places. It has very reliable, very cheap energy compared to a lot of other places.
Now that was a heresy.
Yeah, see, I knew I would get to it's a safe space. Obviously, I support permitting reform stuff. For me, I think one of the biggest issues is the litigation risk, because that drives a lot of things through this interim effect, even if it doesn't go to litigation. So I would say that you really have to tighten down who can go to court. It's one thing if you have a property right that's going to be damaged in some concrete way by a project. It's another thing if you're talking about the kind of very amorphous climate fear injuries that people use to get to court in many instances. And I would say that this doesn't necessarily have to have a congressional solution. I believe that the APA has been misunderstood. There's an excellent article by Caleb Nelson at UVA that explains how the arguably within the zone of interest of the statutory standing test is based on a misunderstanding of the original data processing case from the 70s. If we were to go back to an APA originalism, or at least a data processing originalism, it would significantly shrink who can go to court on a number of different things, including NEPA. I would also say the stranglehold on nuclear should be loosed to some significant degree. I wasn't allowed to watch The Simpsons when I was a kid, and I think my mom's injunction still stands, but I unironically joined with Homer's prayer, thanking God for nuclear power, the safest, cleanest, safest energy source there is, except for solar, which is a pipe dream. Obstacle 2 that I'll discuss is the drive to electrify the nation's auto fleet. The President's August 5th executive order from 2021 says that the administration's goal is 50% of new passenger cars and light trucks sold by 2030 to be zero emissions. Now I'm one of the lawyers challenging the regs that have sought to implement that, so I won't get into the admin law issues, but on the policy side of things, I will say electric cars are not a cost-effective means of reducing carbon dioxide emissions. And they're not practical for many applications, and they are very expensive. How expensive? Even with the subsidies baked in, and the tax credits and all that. Average electric vehicle cost new is around $67,000. For your average car, it's about $48,000, and for a subcompact, it's about $23,000. I think this disparity and total costs are going to go up as we continue to try to have more electric cars in the fleet, because the critical mineral supply needed to make them is already being quite stretched, and for many permitting reasons that we've already covered, it's hard to build new mines. The Biden administration has I think tanked the 3 copper mines that have been on the table since his administration started. Percentage, of course, is determined by numerators and denominators, and so if you have a percentage requirement and you can't change the numerator, you're going to have to change the denominator, and that's going to be accomplished by increasing cost. And also, because of the perverse way that we regulate cars, where you get kind of a golf handicap the bigger the car is. It's a lot, for automakers it makes sense to make bigger, more expensive cars and SUVs and trucks. And these are, even if they're electric cars, have a higher carbon intensity. So I think the result of this is a cubification of the affordable car market, where everything that's currently on the road will be kept on the road for a very long time. And I think that's going to hurt the poor, hurt the economy without improving net emissions much. Final observation of an opportunity with this is I think that in the drive to get electrification accomplished, other ways of improving efficiency and thus reducing emissions have been left to the wayside. In particular, we could adopt an octane standard like what they have in Europe, where you get about 5 to 10% better fuel efficiency pretty much instantaneously with new cars by switching to higher octane fuel. You can also get higher octane ratings by blending in more ethanol, which has a lower, if it's made from corn, or sugar has a lower carbon intensity than gasoline. But that's been something that the EPA has not wanted to get into. Final point, I'll make it very quickly, is carbon leakage and arbitrage. When you're talking about the US versus other countries, I think the excessive domestic focus of a lot of climate activism has the effect of driving a lot of manufacturing and other carbon-intensive industries away from the US. And of course, wage arbitrage is a big part of this too. But by doing that, you're moving manufacturing to places where it's going to be much more carbon intensive. So, for instance, steel made in China releases twice as much GHG emissions that it can direct to the US. So reshoring is sort of a popular thing, I think, on a lot of the right, is an opportunity I think that folks should take, but unless you have a truly net view of net neutrality or net zero, you're not going to make progress with that. So with that, thank you.
So we've heard a lot about transmission planning today, and that's because it's such a critical linchpin for renewable energy development for vast swaths of the country. Where the energy source is not where the demand is, and so now the hot topic is where are these transmission lines that are critical to move energy from where it can be generated to where it is needed. Up on the slide is an image from a report published back in 2021 that was of supposedly shovel-ready projects, transmission projects across the country. Almost all of these are 10 years and running in terms of their permitting timelines. 2 have been actually permitted. Up in the top right, we have one of the regional transmission planning's game plans for transmission under 2 different scenarios. They have what they call futures, where they look at various combinations of demand, energy, generation mixes, and they try to figure out what they actually need and are starting to actually prioritize where they need to develop the grid in order to meet the demand and deliver our services reliably. One of the things that's interesting there that I think some of the other panelists touched on is the interconnection queue, which the average interconnection study for a project is now up to 3 years, and a huge number of projects are just waiting in line for that. Of that massive interconnection queue, only about 16 to 23% of those actually get built. So if we're looking at these timely, critical, need them yesterday, energy targets for reliance, affordability, independence, and clean energy, with transmission permitting taking more than a decade, where are we going from here? And that's before you even start permitting. In terms of permitting, you have more than 60 federal permits that may be required from up to 13 agencies. A lot of these have their own policies, handbooks, unwritten policies and procedures. And those information requirements for each project may differ and even contradict each other. That doesn't even include the state and local permits, which we'll get into a little bit more, but that's the complex universe, and that's what most of my conversation with you today is going to focus on. The lengthy timeframes, Again, NEPA is only a part of the process. A lot of times that's seen as kind of the umbrella for everything. We're gonna talk a little bit more about what that actually looks like when projects have an actual streamlined process versus more of a haphazard approach to how agencies conduct the reviews. We have variant information requirements. You see this a lot in terms of the back and forth, even among agencies. A lot of times project developers are blamed for not being able to submit a complete application the first time, the second time, the third time, the fourth time. However, you can also look at interagency consultations, where you have one federal agency often the same office, talking to another federal agency often the same office, and they're going back and forth. 1 time, 2 times, 3 times, 4 times, 5 times, and you still don't have a complete consultation package. So at what point is there a systemic problem that needs to be addressed versus one developer isn't just following the process and submitting the required application materials? Public involvement. I might get in trouble in this one. I don't think the public comment periods are the part that causes delays. That's the critical aspect. If you have a project manager that is managing the process, there's no stop work that needs to occur while you extend a comment period by another month. Instead, the delays are caused by failures in program and project management, workforce planning, interagency coordination, cooperation, and the lack of a centralized location where all of this is actually being held, managed, and agreed upon. Interagency coordination, it takes extraordinary measures to be able to first identify what's required and then to manage it. We're going to show why that's the case in a moment. The regulatory uncertainty, the changes are happening on an unprecedented rate across the board, whether it's statutory, regulatory, policy, resource management plans, and we're going to show how that's affecting projects as well. So here's our showcase of the permits that are required most commonly for energy infrastructure projects on the right. In terms of the dynamic nature of what's going on here. In the 2022 Spring Unified Agenda, this is where the government posts all of its plan changes to regulations. The Department of Interior alone identified 283 planned or in-progress rulemaking. The orange boxes are designating the permits here that have ongoing regulatory changes right now. Went ahead and did another slide on the right that maintains all of the permits. This is federal only, that are most common for energy infrastructure. On the left side now, we did the additional permits required specifically for transmission projects. We did it again for renewable energy projects. Again, on the right are the ones that are most common to all energy infrastructure, and on the left are the ones specific now to renewable energy projects. As you can see, NEPA in the small box over on the right is only one. So permitting timeframes. We hear a lot about the average timeline for NEPA, 3.3 years, 2.4 years. This was a study that was done by my old agency for large scale transmission and pipelines. So those are projects that are $200 million in value or more. That doesn't sound so bad. But when you're doing these kinds of analyses, you're looking at completed projects only. So what are you missing? You're missing all of the projects that haven't yet been completed, that are still ongoing. You're missing all of the projects that were ongoing for 10, 15, 20 years and then quit and died. You also have an interesting situation on where's the starting point? Where's the ending point? That sounds like an easy thing, but turns out it's not. You have projects that were submitted back in 2007. That's when they sent in the first application. Maybe there's an ownership change, and now you have a revised application sent in with a different project being proposed, but it's still under the same process. Or you have just changes to the application because it's a living application. A number of agencies have that, where modifications are made as a result of the process and should be included in that. There's also the question of when permitting ends. Because of the focus on NEPA, a lot of times the focus is on what's called the record of decision, which is what concludes NEPA. However, that's not actually the last federal authorization. That's typically the notice to proceed, which is when the government actually tells the project they can start construction, and that can occur years later. You still have your federal and state potential permitting conflicts. A lot of times, state and county final decisions come well after the federal side, but the interaction between those regulatory agencies may not ranges the full spectrum, and you may end up with contradictory permit conditions. It also doesn't include feasibility programmatic studies. It doesn't include pre-application processes. So there's a lot that gets left for litigation, to the point of number of the folks on the panel. So there's a lot that gets missed when you look at just these, how long do these things take? So what does it look like when we actually pile it up on the schedule? This is the example of Energy Gateway South Transmission Project. This is a very simplified Gantt chart. The part that's circled in green is NEPA. It accounts for less than half of the total permitting time frame. The notice to proceed was completed just last year. Years later. Now, this is an interesting example because this project was included in no less than 6 expedited laws, programs, policies, and commitments across multiple administrations. The final EIS page count for people that are tracking these things is just under 4,000 pages. That does include all the appendices. Now, how many of you think that if you have the government in charge of interagency permitting for a multi-billion-dollar project, how many of you think that there is a schedule that exists? No participation. Let's back that up. How many of you think that someone who's at the lead agency knows what agencies are involved or what permits might actually be required? And let's say we're halfway through the process.
Someone that knows or someone that will tell you they know?
I don't know. So what's interesting is this is another example of a project that was well underway, and yet when agencies were required by statute to publicly post a permitting schedule that has all environmental reviews and authorizations, how'd they do? They missed 4 out of 5 federal agencies with permitting responsibilities. They're directed by statute to incorporate state permits to the maximum extent practicable. They included none. They missed a NEPA review. To the right of the green circled area is an additional environmental assessment that was done. And the final BLM authorization, so what actually allows the project to proceed and be constructed, was not included. They declared all work done in victory with the record of decision. So now what does the actual process look like? Because that, again, was the simplified version of the federal view. To the right, and I don't expect anyone to read this, I didn't want to, but I put it all together. To the far left box, that's all one state, the state and county permits that are required for this project. The next 2 boxes are 2 additional states. The one on the far right is multiple federal, and the long list that you see right kind of 2/3 down, those are all of the parties that had to be coordinated with as signatories for the National Historic Preservation Act, Section 106 consultation. This is a massive process to try to put together and manage. And the fundamental building blocks for program and project management just are not in place. And so the people that are being asked to do this within the federal government are not being set up for success. You see this graphic of the NEPA umbrella pretty commonly. And so everyone thinks that NEPA just covers all of this. And if I just simplify NEPA, I wouldn't have to do all these other things. But you could get rid of NEPA, you could have the waiver, you could do the CADX, but you're still gonna have to do the vast majority of those analyses under these other environmental laws and requirements. NEPA is the organizer. And so NEPA is critical, but it's only a part of the permitting process. It requires an incredible amount of expertise and project management experience to have that NEPA not get blown upside down in the storm of permitting. And we did an analysis about 1.5 years ago where we looked at all of the project management jobs that were posted for infrastructure permitting. Not one actually required project management experience or training. So,
Thank you. So we have gotten ourselves into a time crunch here. We've got those who are taking the shuttle to Kempon, we loaded up in about 7 or 8 minutes. But I did want to try to squeeze in a couple of questions here if we can, and I'll take the moderator's prerogative to just make a point to Professor Adelman. You showed that I was struck by the slide showing that EISs are required for about 2 or 3% of reviewable project numbers, which is an interesting data point in just looking at raw numbers. But have you come across data that shows projects subject to an EIS as a percentage of capacity, of electrical capacity? Because I bet you that you will. I strongly suspect that this is one of those situations where the projects that don't require EISs tend to be 50 or 100 acres, and the projects that do require EISs are 10,000 acres. And so the numbers are likely to be that maybe 30, 40, 50% of capacity deployment will require an EIS. Do you have a sense of that?
I doubt that. I mean, just think about all the capacity that's built in Texas. There's no EIS, no EIS in Texas.
Texas is sort of like this happy EIS free zone.
The problem is that if you look at where the EISs are there, it's actually not the states with the largest capacity. Other than, well, yeah, I mean, it's not even Iowa, because, the states in the Midwest were more like Indiana and Ohio. And they have some names, but they're not their native names. So, I think it's doubtful, certainly for wind. For solar, it's definitely true that there are some really large solar projects that are subject to EISs, and they're all, again, sort of concentrated in California and Nevada and that area. But I don't think it's a majority of capacity.
So, question for Professor Adelman and Ms. Hanley. So the IRA's own proponents say, the repeat project that one of you showed, say that transmission needs to the production of transmission needs to significantly increase. I've heard some of you say that permitting is a big problem, but then it sounds like you were saying maybe it's not. And then some people have said that consultation is a problem, not on this panel, but elsewhere. And I think you said that it's not. What else could it be?
So let me be really clear. I was only looking at a subset of permits. I was not looking at the full path of all federal permits and certainly no state or local sign-off. So I was just, in part because there's been just a lot of focus, particularly on NEPA, but other environmental statutes. So I think transmission is enormously difficult. The things that I've heard are the major holdup are a lot of the state and local opposition. And I've heard less about the federal permitting, but it's also something that's not what I'm familiar with. I'm familiar with the environmental permitting, but there's other federal permitting that has to go on, and I think you know that much.
Yeah, and let me just jump in and say we have to bring the panel to a close, unfortunately, but I do want to point out a fantastic paper that Michael Buschbacher wrote called "The Gaslighting of America," about the FERC, about the transmission lines problem. And I'll just say something about this that this is the transmission lines are really the long. I mean, there's no way to get to net zero without building 100 new nuclear plants, which is a whole issue of itself. We haven't built 3 new nuclear plants in the United States since 1980. And because of the permitting hurdles, but that's a whole other issue. The real long pole in the tent of all this is transmission lines, because the solar and wind, you have to build those where the sun shines and where the wind blows. That's not where the populations are, so we already have 1 million miles of 600,000 miles of transmission lines in the United States. We cannot use that network for the new deployment. We have to build transmission lines out to the middle of nowhere where the solar projects are. And so what you're going to see is solar projects that do manage to get through the permitting process and get their permits or don't need them, sitting in the middle of nowhere, waiting, like in the John Beckett novel, for the transmission line to arrive. which might not happen in 15 years or ever. And the transmission line problems, take a close look at those, because the studies that I've seen are 600,000 miles of new transmission lines, or 1 million miles of new transmission lines for 2050 to meet the Paris goals. And just look at the problems that have been attendant on a single 700-mile transmission line that took more than 15 years to permit. Just an odyssey of that just reminds you of the Miami Dolphins trying to get down the field. At least not before the last couple of years. Just a really painful thing to watch. So anyway, these are big problems. You've been at the front lines of it. You've been at the front lines of it on the litigation side. Professor Adelman, you're a lot of people looking to you for answers on this as well, and something that deserves more work in the years ahead. So thank you all. That concludes the first day of our conference. There's a shuttle outside waiting for those going to CAMPOM. We're confirmed for CAMPOM, and I will see you all out there. Thanks.